given are negligible. And second part is that the credit has been given not only for the agriculture purpose, but other agriculture credit has also been given. So these are the two issues on which the AO has denied the claim of the SSC under 80P. Now, after CIT appeal, after ITT, the matter has reached to the Kerala High Court. The decision of the assessing officer was challenged in the Kerala High Court. The court, in the court, when the court was there, the SSC has relied upon the division bench. That was the first that went to the division bench of the Kerala High Court. And the SSC relied on the Chirakkal case. That was the Chirakkal case Cooperative Bank Limited. That was the CIT versus CIT. That was 2016 384 ITR 490 case, which was reported. And the High Court, after considering the 80P4 of the Act, various provision of the Kerala Act, Banking Regulation Act, bylaws of the society, held that once a cooperative society is classified by the registrar of the cooperative society under the Kerala Act as being the primary agriculture credit society, the authority under the Income Tax Act cannot probe into whether the agriculture credit society, whether the agriculture credit were in fact was given by such society to its member, thereby going behind the certificate so granted. Here, it is very much important that while assessing, while AO has invoked the section 133.6 and going through the 133.6, he has observed that number of the member to whom the credit was given, or in fact to whom the credit was given, was very less. In fact, it was negligible. And these credits were not only with the agriculture credit, but there was other credit also, like credit for the opening of some shop, medical shop, some cycle shop, some other godowns also. These were the credit that was given to the member as well as non-member also. What the High Court has decided? High Court has relied on the Chirakkal Services Cooperative Bank Limited that came in 2016, and that was reported in 384 ITR 490, and it was Calcutta. It was a Kerala High Court case itself, and the division bench of the Kerala has relied that the 80P4 of the Act, considering the section 80P4 of the Act, various provision of the Kerala Act, that is the Kerala Cooperative Society Act, Banking Regulation Act, because it will affect the banking regulation also, bylaws of the society, held that once a cooperative society is classified by the ROC, that is the ROCS, I will say, the Registrar of Cooperative Society under the Kerala Act, as being primary agriculture credit society, then the authority under the income tax cannot probe into whether the agriculture credit were in fact were given by such society to its member, thereby going behind the certificate so granted. So AO is trying to lift the corporate bill. AO says, even though you have been granted the certificate by the ROCS, but in fact you have not complied with the bylaws, and therefore since you have not complied by the bylaws, you are not eligible for the purpose of 80P. However, the High Court relies on the Chirakkal case, and Chirakkal says that no, the AO is not entitled to go beyond the certificate granted by the ROCS. And once our ROCS has given the certificate, it is complied with the registrar. It is complied with the Societies Registration Act, and once it is complied with that Regulation Act, the AO cannot go beyond that certificate here. So that is the one point that is there here. High Court held that since all the SSC were registered as a primary agriculture credit society, they would be entitled to deduction under 80P2A1, read with section 80P4 of the IT Act. Very good here. Even though High Court says that even though 80P4 has come, these credit societies are the primary agriculture credit society. Therefore, they will not fall under the 80P4 of the Income Tax Act, and therefore the benefit of the ATP2A01 will be available here. So this is the primary foundation where the dispute has started, and I will tell you that how a dispute has come to the Supreme Court here. But before this dispute has come to the Supreme Court, there is another here. Another important milestone is that, but department didn't agree with this division bench judgment here, and this was challenged in the larger bench itself, in the full bench. In fact, I will say that it was a full bench in the Kerala High Court itself. The department contended that the judgment of the Chirakkal case, Supra, rendered per inquirium. Department says that this judgment was in inquirium, so therefore any reliance on this judgment cannot be a good law. And notice that the earlier decision of another division bench in the Kerala High Court, that is the Printha Lamana case, Service Cooperative Bank, 363 ITR 268. It was held that it was a revision case here. The revision authority was justifying, saying that the inquiry has to be conducted into the factual position as to whether the cooperative bank is in fact conducting business as a cooperative bank and not as a primary agriculture credit society. And depending upon whether there was so for the relevant assessment here, the assessing officer would then allow or disallow deduction claimed under ATP of the IT Act, notwithstanding that the nomenclature of the registration certificate issued under the Kerala Act would show that the SSC are primary agriculture societies. This divergent decision led to the reference dated 9/7/2018 to the full bench of the Kerala High Court. So there was a divergent opinion by the same court on the two matters here, and the department relied on the Printhalaama Services Cooperative Bank Limited, and it held that the AO has the power to go to look into the detail and it to say that whether the SSC has complied all the requirement of the Cooperative Society Act or not, and therefore it can lift the corporate bill here. Let's see what the full bench says here. The full bench order, which has been challenged by in the Supreme Court, the full bench referred the full bench by the impugned judgment referred to Section 80P of the IT Act, various provision of the Banking Regulation Act. So now the full bench has invoked the Banking Regulation Act, Kerala State Cooperative Society Act, and held that main object of the primary agriculture credit society, which exists at the time of registration, must continue all the time, including the assessment year in question. It says that once you have availed the exemption and once you have complied the condition, this condition has to be complied in year-to-year basis. It cannot be said that once you have already complied, after that you will not comply. So that has to be complied on year-to-year basis here. After that, it says that notwithstanding the fact the primary agriculture society is registered as such under the Kerala Act, yet the assessing officer must be satisfied that the particular assessment year, the main object, and in fact being carried out. Further, it says that even though you are registered here, that the AO can verify whether you have carried on that activity or not. If it is found that the matter of fact agriculture credit amount or negligible amount, then it would be open for the AO applying the provision of ATP 4 of the IT Act to state that the cooperative society in question, though registered as a primary agriculture society, is not in fact functioning as such, and the deduction claimed under ATP of the Act must be refused. So it says that if the AO has come to a finding that even though it is a negligible number of the members to whom the loan has been given, then the AO can revoke the deduction which is available to the SSC under ATP 2, and that it can, and therefore it can deny the deduction to the SSC here. The conclusion has reached after the referring to the judgment of the and relying heavily on the Citizen Cooperative case, the Citizen Cooperative Society 397 ITR 1. It was reported and it was a Supreme Court judgment, and this judgment has came from the Andhra Pradesh here, and here in this case, Andhra Pradesh Cooperative Society Act was discussed here. So now we can see that the matter has started from the Kerala High Court, In fact, it was a Kerala. Earlier, it was on the Chirakkal case that was decided. Based on the Chirakkal case, the division bench of the Kerala has given order in favor of the SSC, allowing the deduction under ATP. However, there was a contradictory judgment in the Kerala High Court itself, and in that case, that this matter was referred to the full bench of the Kerala High Court, and the Kerala High Court full bench of the High Court has reversed the judgment of the division bench of the Kerala, and therefore that full bench order is subject matter of challenge before the Supreme Court. Now we are coming to the Supreme Court here. Before coming to the Supreme Court, let's see what the order was passed here. And because why I'm trying to lay the emphasis on this part here, because it is important to understand how the full bench of the Kerala has taken up this matter, how they have misplaced their conclusion on the relying on the citizen case. That was citizen case was reported on 397 ITR 1, and how this matter has landed to the Supreme Court. And further we'll see how the argument has been taken place. The conclusion of the full bench is as follows. I have tried to copy the full bench order from the order itself here. So there is no cutting here. It is not my words. But let's see what was the order of the full bench of the Kerala High Court, because this is the matter which is going to be that here the revenue has to assail this order in the Supreme Court, and the SSC has challenged this order itself here. What does the Kerala High Court says here? In view of the law laid down by the apex court in the Citizen Cooperative Society, very much important to understand what was the Citizen Cooperative Society case was 397 ITR. It cannot be contended that while considering the claim made by the SSC Society for deduction under ATP after the introduction of the subsection 4 thereof, the AO has to extend the benefit available merely looking at the class of the society as per the certificate of registration issued under the Central Cooperative Society Act and the rules made thereunder. It says that as per the citizen case here, and after this ATP4 here, the AO can go beyond the certificates here, and the AO cannot say that, okay, I will look at the certificate, but he can very well go beyond the certificate here. On such a claim for deduction under ATP of the ITR, the assessing officer has to conduct an inquiry into the factual situation as to the activities of the SSC Society and arrive at a conclusion whether the benefit can be extended or not in the light of the provision of the ATP4. Now the issue arises here whether the AO has to go to the detail of the society after coming into the effect of ATP4, or it can, even though ATP4 was not there, even though the inquiry was required for the purpose of the SSC AO to grant the benefit of the ATP here. My understanding is that if you go through the ATP subsection 4, earlier this provision was there I feel that provision was there up to 79, but after 79, this provision was omitted. And again, this provision has come from the Finance Act 2006 with effect from the 2007. So therefore, it gives us a clear picture that what happened prior to 79, what happened after 79 till 2006, and after 2006 till now, what was the role of the AO? Can the AO yes go to a detail to find out whether the SSC was required to comply with the Society Act or not? And it says that here the larger bench, either full bench, rely on the Citizen Cooperative Society case, and it says that AO has the full right to go for the detail here. I will come to the next slide. What the full bench says. Then after the full bench try to distinguish the Judicial case here. Judicial case, that was 384 ITR 490. The division bench held that the appellate society, having been classified as the primary agricultural society by the competent authority under the KCS Act, that the Kerala Cooperative Society Act, it has necessarily to be held that the principal object of such society is to undertake agriculture activities and to provide loans and advances for the agriculture purpose. The rate of interest of such loan and advances is to be rate as fixed by the ROCS under the KCS, and having the area of operation confined to the village, panchayat, and municipality as such, and they are entitled to benefit of the subsection 4 of the ATP of the Act to age themselves out from the coverage of ATP, and that the authority under the IT Act cannot probe into the issues or such matter relating to the societies, and therefore the primary agricultural society registered under the KCS Act and classified so under this Act, including the appellant, are entitled to such exemption. So it discussed about the Chirakkal case. Chirakkal case was there, that how the Chirakkal case, the exemption was given under the ATP 2, even though ATP 4 was there. However, then the full bench distinguished the Chirakkal case here. In Chirakkal case, the division bench expressed the divergent opinion without noticing the laid down the case of in the Anthony case here, that was the 2003 Kerala High Court case, and the Printhalama case, that was 363 ITR 268. Moreover, the law laid down by the division bench in the Chirakkal case is not a good law. Now, division bench says that no, it is not a good law, since in view of the law laid down by the apex court in the Citizen Cooperative Society. So the full bench is relying on the Citizen Cooperative Society case here on a claim for deduction under ATP by region of the subsection 4 thereof. The AO has to conduct an inquiry on the factual situation as to the activity of the SSE society and arrive at the conclusion whether the benefit can be extended or not in the light of the provision of ATP 4 of the Act, in view of the law laid down by the apex court in the cooperative society, law laid down by the division bench in the Printhilama has to be affirmed and we do. So based on this part, the full bench has reversed the judgment of the division bench, which was relied on the Chirakkal case here. In view of the law laid down by the apex court in the multi-X system case, since the assessment year is a separate unit, the intention of the legislature is in no manner defeated by not allowing reduction under ATP of the IT Act by region of subsection 4 thereof, if the SSC society ceases to specify cases or society for which the deduction is provided, even if it was eligible in an initial year. It is a very good, in fact, line from the division from the full bench here. It says that each year is a separate year, each assessment year is a separate year, and it says that in view of the law laid down by the apex court in the ACE multi-assess system that was there, since each assessment is a separate unit, yes, we know that each assessment is a separate unit, the intention of the legislature is no manner defeated. That it was argued by what was the intention of the legislature. It says that intention of the legislature in no manner defeated by not allowing the deduction under ATP of the Act by region of subsection 4 thereof, even though it was eligible for in the initial year. So now we have come to the Supreme Court. We have seen till now that how this matter has reached to the Supreme Court. It was the SSC, it was the AO who has disallowed the benefit of the ATP2 due to the provision of ATP 4, and after this it was a division bench of the Kerala High Court which has come to which has given the order in favor of the SSC, relying on the Chirakkal case. However, this matter was referred to the full bench because there was a divergent opinion in the parental cases there, and after that the full bench has reversed the order of the division bench of the Kerala High Court, and therefore this matter has reached to the Supreme Court. And now see how the matter is going in the Supreme Court here. How now the SSC is arguing the ATP 4 here. I'm written here the few line that is there, that is about the ATP. What is the SSC argument is that? SSC argues that ATP4 has not led to any change insofar as the appellant SSC is concerned. The first liner is that the argument is that even though the ATP4 has come, then it does not it does not affect the SSC. Then we will say what is the effect of the ATP4 here. And for this purpose, if we go through the statute here, if we go through the statute, we can find out what the law says here. Law is about the ATP2. ATP is heading is deduction in respect of the cooperative society. So the deduction is to a cooperative society. It says that where in the case of SSC being a cooperative society, the SSC should be a cooperative society. The gross total income includes any income referred to in subsection 2. The first condition is that SSC should be a cooperative society, and the gross total income, the GTI, should include any income which is referred in subsection 2. There shall be deduction. There shall be deduction in accordance with and subject to the provision of this section. So first condition is that first is the eligibility condition. An eligibility condition says that the SSC should be a cooperative society. Second condition is that the income should be, there should be one of the income. The gross total income includes any income. The word any is very important. Any income referred to in the subsection 2. If the gross total income includes any income of the subsection 2, then you are qualified. Then it says, then there shall be deduction in accordance with and subject to the provision of this section, a sum specified in subsection 2. If the SSC has qualified for this purpose, both if the cooperative society and the income includes any of the income which is mentioned in the subsection 2, then there is a quantum of deduction is there, and what is the quantum of deduction has been specified in each of the case. Subsection 2 says the sum referred to in subsection 1 shall be the following, namely. What are the sum referred to in subsection 1 shall be the following, namely. It says about the sum which was mentioned in the ATP1, and this is the ATP2. We have the ATP2A that says that in the case of cooperative society engaged in. So ATP2A has, in fact, has 4 limbs. First limb is in the case of cooperative society. Second limb is that in the case of cooperative society being a primary society engaged in supplying milk, wild seed, fruits, and vegetables raised or grown by its member. C talks about the cooperative society engaged in activity other than specified in the A and B. D talks about the in respect of income by way of interest on dividend derived by the cooperative societies. E talks about the income derived by the cooperative society from the letting of the godown or warehouse for the storage here. And in the case of the cooperative society not being the cooperative society, in the urban consumer cooperative society or society carrying on the transport business. So these are the 5 limbs of the ATP2. After that, the ATP3 is that it says that in case where the SSC is entitled to deduction under ATHH or ATHHA, so what should be the quantum of deduction that will be there? The issue is on the ATP4. The ATP4 says the provision of this section shall not apply in relation to a cooperative bank. The exclusion is in respect of the cooperative bank. The exclusion is not in respect of the cooperative society. So therefore, the ATP, what is the ambit of the ATP? ATP ambit is, it says that the provision of this section shall not apply in relation to a cooperative bank. So point that we have to understand that what is the difference between the cooperative society and a cooperative bank. Whether the cooperative society includes the cooperative bank or it does not include the cooperative bank. If it does not include the cooperative bank, so what is the meaning that bringing this provision here? So whether this ATP4 carve out something from the ATP2 or it does not carve out something from the ATP2. We have to understand this part here because the total judgment is based on this part only. The provision of this section shall not apply in relation to a cooperative bank other than primary agriculture society. it says that yes, it will not apply to a, because it will not apply the provision of this section shall not apply to the cooperative bank. Further, it says the primary agriculture credit society. So this benefit will also be there to a primary agriculture credit society or a primary cooperative society, agriculture society, and a rural development bank and a rural development bank. If these conditions are there, other than these ones, and a rural development bank. So if we understand this part here, the provision of this section shall not apply in relation to a cooperative bank. From the cooperative bank, we have to out the primary agriculture credit society or the primary agriculture society and rural development. So these two banks, cooperative banks and the rural development bank, is out of the ambit of the ATP because of the ATP4. The question that will arise here, whether this primary agriculture credit society is if it is a society, can it be termed as the can it be called as a cooperative bank, and under which situation it will be called a cooperative bank here. So we have to understand the section ATP, ATP2, and mainly the ATP4 here. Okay. Now, what is the argument of the SSCs? SSC says here, first argument is that the ATP4 has not led to any change insofar as the appellant SSC is concerned. Why the SSC is saying like this one? Because he is relying on the term cooperative bank. The SSC argument is that I'm a cooperative society. Although I'm a cooperative society, I'm into the business of the lending the money to my members, or even the lending the money for the agriculture purpose or any other purpose here. But I'm not a cooperative bank. So there's a two different terms that is coming out. I'm an agriculture society, but I'm not an agriculture bank. I'm not a cooperative bank here. That is the main argument that is there. Since I'm not a cooperative bank, I'm not covered under the ATP4, and therefore the issue of the ATP4 will not arise to me here. At least this first line is said. His main argument is based on the language of the ATP1 and ATP2, is that the ATP2 is a beneficial provision. Now we will go how to read the ATP1 and ATP2 provision, which is meant to further, which is meant for the furtherance of the cooperative movement in India. For this purpose, certain income of the cooperative society, once it is registered under the State Act, becomes deductible from its gross total income. According to him, the moment of the cooperative society is registered as such, is engaged in the providing credit facility to its member, the inquiry of the assessing officer stops there. It says that the AO should not inquire further. And why he is arguing, why the learned senior counsel is arguing like this one here? Let's see into this part here. What the law says here, and we will come to this part, because each of the line of the judgment is important. So I have tried to capture each argument of the learned counsel here, and to understand why a learned counsel is arguing like this one, because it will help us to understand and how to frame the argument when we are in the court here. It says that the sum referred to in subsection 1 shall be the following, namely, in the case of the cooperative society engaged in, because the term engaged in will be deliberated a lot, we will come. In the case of a cooperative society engaged in, first there's a few up to, there's a 8 conditions are there. First says, carrying on the business of banking. It says that if you are carrying on the business of banking, but it does not say you have the banking license. Please understand here, because it will create a difference here. Carrying on the business of banking or providing credit facility to its member. There is two parts here. Carrying on the business of banking or providing credit facility to its member. So if you are carrying, if the cooperative society who is carrying on the business of banking, we will understand, we will come to the what will happen if whether the cooperative society can carry on the business of banking, but he is still not a cooperative bank. That is the main question that will come here. Can a cooperative society can carry on the business of the banking, but he is not come into the ambit of the cooperative bank. And the second part is that the providing credit facility to its member. If he is doing, if he is providing the credit facility to its member, then he is eligible for the purpose of ATP2. It does not say that he has to only the member. It says that he has to member only. It says that you have to provide to the members. But the section does not say or does not debar the cooperative society that you cannot provide any loan or any credit facility to a non-member. So therefore, we have to understand, it says that it has to be either carrying on the business of the banking. Yes, if you are carrying on the business of the banking, or providing credit facility to its member. The moment you have provided a credit facility to its member, even though it is negligible, you are covered under the ATP2A. It does not say that use that to a non-member, and it does not debar a cooperative society to give a loan to a non-member also. So the qualification is for this purpose here. Second is that if it is a cottage industries. Third, which will be discussed, that will be discussed in detail here, the marketing of the agricultural produce grown by the members or you say that marketing of the agricultural produce. It says that if there is it is a marketing of the agricultural produce grown by its member or. Fourth is that the purchase of the agriculture implements, seeds, livestock, or any other livestock, other articles intended for agriculture or for the purpose of supplying them to its member, or the processing without the aid of power to the agriculture produce member to its member, the collective disposal of the labor or its member, fishing or allied activity, that is to say, to the catching, curing, processing, preserving, storing, marketing, or fees to purchase or material or equipment connection therewith for the purpose of supplying them to the members. The whole of the amount of profit or gains attributable to any one of the more such activity. Here the law of attribution starts here. It does not say, first of all, it says that the moment you have provided the loan or credit facility to its member, then you are eligible. But what will the deduction will be there? The deduction will be that the whole of the amount of profit and gains of business attributable to one of more such activity. So the point that I'm trying to say, there is one condition is for the eligibility condition, and the second condition is for the attributable condition. Here the issue is on the fight is on the eligibility, whether the cooperative society is eligible or not. It is not on the attribution of the income, but it is not on the quantum of the deduction. It is on the eligibility of the deduction. So here the argument is that the argument is saying that I'm eligible for the purpose of deduction the moment I have complied the condition of the ATP1 and ATP2. What will happen to the attribution? It is nothing to worry, because that is not the question that has come before the Supreme Court. So therefore, this argument is that the para 2, his main argument based on the language of the ATP1 and ATP2 is that the section ATP is a beneficial provision. Now come to the how it is a beneficial provision. How we understand the term that it is a beneficial provision, and if it is a beneficial provision, what should be the law of interpretation shall be used, whether it should be interpreted literal, or whether the ambit will be wider, or whether it should be a purposive interpretation has to be given here. Because the many more debates that will come after this one, whether that will on the debate that how this interpretation has to be given here. The argument of the council is said that why this cooperative section ATP has come. Before this section ATP, there was section 81 with the same language, and it says that he says that argument based on the language of the ATP and ATP1 and ATP2 is that the section ATP is a beneficial provision which is meant to furtherance of the cooperative movement in India. We know that after the independence, there was a cooperative movement in India. There are a lot of amendment has come, and it was a part of the constitution itself here. What will the cooperative societies? It was there, and therefore during the cooperative movement, the section has come. For this purpose, certain income of the cooperative society, once it is registered under the State Act, becomes deductible from the gross total income according to them. As I said, the moment the cooperative society that the registered, according to them, the moment a cooperative society is registered as such, is engaged in the providing credit facility to its member, the inquiry of the AO should stop there. It says that here what we have learned in the Vodafone case, look at and look through. Here the argument is that here the council is arguing that once it is registered with the Credit Cooperative Society and the ROCS has given the certificate, you should go with the certificate only. You should not go beyond the certificate only. So therefore, the issue that is there about the form versus substance here. It says that once the ROCS has given the certificate, then this certificate should be achieved the finality. And the AO should not go beyond the certificate. And the issue we will discuss also, what will happen if the condition of the certificate is not complied? Can the AO invoke that certificate? The answer is no. Who can invoke? It is only the ROCS has the power to invoke here. We will come into this part here. So this was the argument that was taken place here. And after that, the third argument was that the full bench was wholly incorrect to adding credit facilities related to the agriculture, as no such things contained in the ATP 2A1. It is very much important. The department was arguing that it should be an agriculture credit here. But the term ATP2, it says that in the case of cooperative society engaged, carrying on the business of banking, carrying on the business, in the case of the cooperative society engaged in carrying on the business of banking or providing credit facility to its member. It does not say it should be the agriculture credit facility. Any credit facility can be ambit on this part here. So therefore, the law does not say that it should be only the agriculture credit society. Agriculture credit society will come in the case of B, where it says that in the case of cooperative society being primary society engaged in supplying milk, oilseed, foods, vegetables raised or grown in the mills to a federal cooperative society, or it will come into the 3, A, B, C, C here. But as far as the 1 is concerned, it says that providing credit facility to its member. It does not say it should be the agriculture credit facility. So therefore, the argument is that it says that the full bench has wholly incorrect in adding the credit facility related to agriculture, because ATP2A1 never emphasizes that it should be an agriculture facility, and as no such things is contained in the ATP21, as contrast to the ATP 3 to 5. If you go to the 3 to 5, we can say that the marketing of the agriculture produce shown by the member or not. 4 says the marketing, the purpose, the purchase of the agriculture implements. 5th say the processing without the aid of the power the agriculture produce. So it is the word agriculture is coming in the clause number 3, 4, 5. It is not coming into the clause number 1. So therefore, the argument is that it is a misnomer that the AO has to look into the agriculture, and their SSC AO say that no, it should be the agriculture loan only. The SSC said even though loan is or the credit facility is given for non-agriculture purpose, they are qualified to be covered under the ATP 2.1 if it is given to its member, or even though it has been given to its member, non-member also, they are qualified. However, when we'll go to the quantum, yes, non-member issue that will be not deducted here. It was argued the moment the cooperative society is engaged in registered under this act, whether it is whatever be the classification, as long as it provides credit facility to its member, which need not to be credit facility related to agriculture, it is entitled to deduction under the section ATP 2.1. It says that even though the moment it is registered here, there is no need to go for the further classification, whether it is an agriculture credit cooperative society or not. The law says it should be a cooperative society. The moment it is a cooperative society, no need to go for the further classification. Only the thing that you have to observe that yes, it is a cooperative society and the credit facility has been given to its member. The moment it has been given to the member, that it will qualify for the purpose of deduction. However, when we go for the quantum, then we can see. Sorry, this is a bit small here. I'm also not able to read here.
सर इसे स्लाइड शो में अगर करेंगे तो थोड़ा सा और इंक्रीज हो जाएगा इसका साइज.
Yes, yes, मैंने कर दिया मैम. Now it's
yes. Okay, sir.
I hope that I'm going a bit slow, but I'm trying to explain the complete law.
Yes, sir. Yes, that is the beauty of this.
Yes,
I'm step by step we are getting to understand कि कैसे process बढ़ता है आगे.
Yes, yes. I'm not hurried to complete this one. I'm trying to go slow so that everyone who is here should understand the law and should understand how the judgment goes on. And so I'm trying to read the statute along with the judgment also.
Yes.
And I'm trying to read all the arguments that is given by the council here, because I understand that here a lot of chartered accountants are here. And as a chartered accountant, it is our interviewer how to do a good argument before the court here, how to do a good argument before the CIT appeal, how to do a good argument before the tribunal also. So if we understand the flow, then we can understand this part here.
Yes, absolutely, sir.
Now, what is it says here? A distinction must be, now what is the argument of the council here, SSC council? A distinction must be drawn, therefore, between the eligibility for the deduction and whether the whole of the amount of profit and gains of business attributable to any one or more such activity under the subsection is to be given. Here the argument says, this line says, there are two conditions. One is the eligibility, one is the attributability. The argument is on the eligibility of the deduction. Once you are eligible, how much it will be deducted is a separate issue. So the argument is that, yes, at the threshold, I am being qualified for getting deduction. How much I will get the deduction, that is subject matter of the quantification, and that AO should do it here. And the fourth part is that if the credit facility were given to a non-members, for example, such credit facility would not be attributable to the activity of providing credit facility to its member and would therefore not be entitled to deduction under ATP. The learned counsel of the SSC fairly agrees that yes, if I have not given to the non-members, I will not get the deduction for that part. But as far as the members are there, I am eligible for the purpose of ATP. Further, other provision of the ATP, such as the ATP 2B, where the society must be primary society engaged in the supplying milk before it can claim the deduction, which is absent in the ATP 2A1. So we will go to the detail how it was there. Now the council rely on the finance minister's speech in the Lok Sabha and how the Lok Sabha in the Lok Sabha and how when the Finance Act 2006 came, what was the narrative of the finance minister, and at the time it was Mr. P. Chidambaram who was the finance minister, and the SSC is relying on the statement of the finance minister at the in the Lok Sabha, and when the Finance Act 2006 was moved and the amendment of the ATP was introduced by section 4 thereof. The object of the amendment was to remove the cooperative bank from the section ATP 1 and ATP 2, as such bank, like other commercial bank, are lending amounts to the members of the general public, and therefore the merely by being a cooperative banks should not be entitled to avail the deduction under the ATP. So very much important part was that this amendment came through the 2006, and in the 2006, when the budget was moved, it was stated that the cooperative bank should be at par with the other bank because they are into the lending amounts to the members of the general public, and therefore merely by being a cooperative bank should not be entitled to avail the deduction given under the ATP. So they should not have availed the deduction under ATP. Now the question arises whether prior to this amendment, whether the cooperative banks was allowed to avail the benefit of ATP. My personal answer is that no, still they were not allowed, and I will come why it was not why it was not allowed. So the issue was arise, what was the 80p4 amendment was there? Whether it was a clarificatory amendment or whether it creates some right or it really some impact. We will come into this part here. According to him, this means according to the learned counsel, since none of the SSC are cooperative banks, says that in this case, none of the cooperative SSC are cooperative banks licensed by the RBI. Very much important. When we are talking about the cooperative banks, we have to go to the RBI for getting the license to carry out the banking business. Section 80p4 has no application. He argued that any inquiry whether the SSC is a primary agriculture credit society has to be outside the 80p4, should not be any in manner cut down the beneficial provision contained in 80p1 and 2, as the section 80p4 in the nature of proviso, which cannot cut down the main enacting part here. Very much a very good argument here. What is the role of the 80p4? Where the 80p4, although it has come as a separate section, but 80p4 says that 80p4 works like a proviso. And if it is a proviso here, what should be the role of the proviso? What should be the role of the proviso? Whether the proviso can carve out something from the top main section, or what is the importance of the proviso under a statute? So we will go into the interpretation of the statute to understand what is the meaning of the term proviso, what is the meaning of the term explanation here. And it has been argued that here, he argued that any inquiry whether the SSC is a primary agriculture credit society so as to outside the 80p4 should not be in any manner cut down the beneficial provision contained in 80p1 and 2, and 80p4 is in the nature of proviso, which cannot cut down the main enacting part, so that the proviso cannot cut down the main enacting part. This is a very important argument that will come here, because Justice Nariman has deliberated on all these issues, and he has deliberated thoroughly on these points here. And after this argument is from Mr. Arvind Datar, because Arvind Datar is also a arguing counsel for some of the cases, so for some of the SSC. So it is these two arguments is from the Arvind Datar. Further, what the Arvind Datar argues, that once the registration certificate stating that the SSC is a primary agriculture credit society is given by the ROCS under the Kerala Act, then sort of such certificate being cancelled under the Kerala Act and rules thereunder, the assessing officer who is an authority for the purpose of collecting the revenue cannot possibly go into whether in substance the SSC continues to be a primary agriculture credit society. Again, Mr. Datar argues that once the certificate has been granted by the ROCS, then the tax officer, a revenue officer, should not go beyond this certificate and say that, and to check whether there is a compliance or not. And the power of the assessing officer is limited here. He cannot go beyond this certificate here. After that, it relies on the CVT circular. The CVT circular 14/2006, that was the 28th of December 2006, containing explanatory notes of the Finance Act 2006. We know that there is explanatory circular that came after the budget is passed, and this circular was 14/2006, which explained the provision of the Finance Act 2006, and the letter of the CVT circular. CVT has given one of the CVT. First was the CVT circular, and another was on the 9th of May 2008, clarification by the CVT, both on which made it clear that the cooperative society cannot be said to be a cooperative bank. Both the CVT circular and the collection explanation says that yes, there is a difference between the cooperative society and a cooperative bank, and the provision of 80p4 would have no application on the cooperative society. It is qua the cooperative bank itself. Now, there was a revenue argument also. Revenue has totally relied on the full bench judgment of the Kerala High Court, and revenue was arguing that yes, The full bench judgment of the High Court is absolutely correct. There is no need to interfere into this part here. So therefore, I will not mention about the argument of the revenue here. I am directly coming into the deliberation which has started in the in the court here. Before this is also argument of the revenue SSC itself. The full bench of the Kerala High Court has completely misread the court judgment in the Citizen Cooperative Society Limited. We will see that how the cooperative society, Citizen Cooperative Society case was there. If the judgment is seen closely, all the SSC contention in the law were answered in their favor. It says that if the judgment has to be seen closely here, then you will find that all the answers were in fact, the Citizen Cooperative Society was in favor of the SSC. However, the Kerala High Court has misread the judgment here. However, on the fact of the case, the fact was held that in the cooperative society carried down illegally or giving loans to the members who had no place under the statute under which it was registered. It was also giving loans to the members of the general public. It could not be said that a cooperative society at all, as a result of which funding of the fact of the authorities below were not interfered by the Supreme Court. There was no argument neither as to whether the finding of the court in that case that the assessing officer is entitled to go beyond the certificate under this particular statute. Indeed, he pointed out that he pointed out that both under the Banking Regulation Act, the Kerala State Act, if the dispute arose as to the classification society as being the primary agricultural society versus being a cooperative bank, it is the RBI alone to decide the dispute of the Banking Regulation Act. That the second argument says that in the next argument it says that the Kerala High Court has totally misread the judgment of the Citizen Cooperative Society. In fact, the Citizen Cooperative Society was in favor of the SSC itself. It is very much important here to understand how to read and judgment. Here, the Kerala High Court has misread the judgment, and here it has misread the judgment. Why? It has read the conclusion. It has not read the ratio decidendi. And there, in this case, there is a lot of emphasis on how to read a judgment here. And Justice Nariman has pointed out what is the ratio decidendi that has to be followed, not the conclusion of the case here. How to read hello? What is the ratio decidendi? What is the law of precedent? We will come to the Article 141 of the Constitution, and how we will know that how the 141, what is the precedent value of the judgment of the Supreme Court, because the law made by the Supreme Court is a law of the land here. So we will go to the Article 141 also. So these are the discussion is on the precedent value, and the argument of the SSC is that yes, the High Court of the Kerala has totally misread the judgment. And which judgment? The Citizen Cooperative Bank judgment. They have totally misread the judgment here. Again, their argument that all the cooperative society, once they are registered under the State Act, are entitled to deduction under ATP. It says that yes, the moment you are registered under the Cooperative Society State Act, you are entitled. The extent of deduction would depend upon the attributability and not the eligibility for deduction. Very important line, because we have to appreciate that what is the attributable and what is the eligibility here. It says no, the extent of the deduction will be depend upon the attributability and not the eligibility. Once it is found having regard to the letter issued by the RBI in the present case stating the appellant cannot be classified as a cooperative bank, once it is found out the license have not been given to the function as a cooperative bank, all the society qualified for the ATP 2.1 for deduction of the granted. Here there is an important development is there. In this society has in fact applied to the RBI to give the license as a banking company. And in fact, RBI has denied them that you cannot operate since you are a cooperative society, since you are a cooperative bank, cooperative society, you cannot operate as a cooperative bank. And so therefore the license has been denied to them. And this part that is being argued by the SSC, that it says that once the RBI itself has denied me the license to operate as a cooperative bank, I cannot be a cooperative bank, even though I have extended the credit facility to the members as well as the non-members. So the important point that I'm trying to emphasize, the extending the credit facility to a member or non-member is a part of the cooperative society. The cooperative society can extend, no problem. But to having a banking business or to having the banking company or cooperative bank, you need a license from the RBI. And in this case, since the license was absent here, so that it was argued by the SSC, since I have no license from the RBI to act like a cooperative bank, so therefore I am not a cooperative bank, which is covered under the ATP4, and so ATP4 is not applied to me. Sorry, it was a revenue argument was there. Revenue argument is said the assessing officer was to be satisfied that the SSC is engaged in. Why the term engaged in is coming here? Engaged in is coming under the subsection ATP2. ATP2 1 says, in the case of cooperative society, engaged in. What is the meaning of the term engaged in? Yes, whether it should be engaged at the initial year, or it should be engaged during the whole year, or it should be engaged at the end of the year. So we have to see that at engaged in, and we will come to know that there is an important judgment of the Supreme Court, how the term engaged in fact, on this term, there is a lot of debate is there. Engaged in activity as a primary agriculture society or giving loans for the agriculture and allied purpose to its member. Loans given for the agriculture purpose by the aforesaid credit society were negligible. The main business, that being a banking, as such the loan were given for the purpose other than agriculture credit. So these are the argument of the revenue. It says that the SSC was not engaged in the agriculture. The SSC was not engaged in, and the second part was that loans was given for the loans given for agriculture purpose was very negligible here, and the main business of the being a banking company, being a banking, so as such loans were given for the purpose other than agriculture credit. So the issue arises here, the most important, when the revenue is arguing this part. In fact, ATP2 itself says, carrying on the business of banking. If the banking business you are carrying, then you are still allowed under the ATP2. So carrying on the business of banking and getting the license of the banking business is something different here, that we should appreciate that part. And here the revenue argument is a bit fussy here. It says that since you have given the loan to its non-member also, it says that your loans given for the agriculture purpose of the society were negligible. So there was no need of the agriculture purpose that we have already discussed here. Further, it says that main business of the being a business of banking. How it is coming the main business of banking? As such, the loans were given for the purpose of the other than agriculture credit. So the revenue is not able to clear-cut point out that how it is a banking business and how it is, if it is a banking business, can it be covered under the cooperative bank? Third argument says, since the appellant were no longer doing business as a primary agriculture credit society, they would be disentitled to any deduction under ATP after the advent of the ATP4. It says that SSC is no longer into the primary agriculture credit society, so therefore the benefit will not be applicable. Further, it says the classification of the cooperative society under the State Act, which is expressly referred to under section 219 of the Act, is of the primary importance, and once it is classified as the primary agriculture credit society, it is only of the activity related to the agriculture was carried out for that eligibility for deduction would arise in the first place under ATP1 and ATP2. So these were the revenue argument. I'm not going to detail here. Then again say the burden of the burden is on the SSC to prove. I'm not going into detail on that part here. Yes, this is important here. This para that I have extracted from the article of the, in fact, bylaws of the society here and bylaws of the marginalized credit cooperative society and what the bylaws says of the. In the bylaws, there are various purpose on which the loan and credit can be given. And I'm summarized here, which is coming into judgment also. It is important to note that though the main object of the primary agriculture society in question is to provide the financial assistance in the form of loans to its member for agriculture and related purpose, its some of the object go well beyond and include performance of banking operation. Yes, it performs the banking operation as per the rule prevailing from the time to time, like opening of the medical store, running the showrooms, the providing loans to member for purpose other than the agriculture. So it says that yes, the society is giving the loan for the non-agriculture purpose also. So there is no doubt into this part. Now the Supreme Court, now the judgment start from here. The Supreme Court has started its judgment first by looking into the Assam Cooperative Apex Marketing Society Limited, Assam versus Additional Commissioner of Income Tax. This is the first deliberation that starts with the Supreme Court, and how the Supreme Court has looked into the section. And here, on this issue, the Supreme Court was on the ATP 2A3. Earlier, the section was 81. However, the Supreme Court, and the same, it was the parametry are the same. And on that section, we are discussing on the ATP 2A3. What that says 82. The sum referred to in subsection 1 shall be the following, namely, in the case of cooperative society engaged in the marketing of the agriculture produce grown by the members, or it was there that the marketing of the agriculture produce grown by its member. Whether this grown by the members, whether it's mean by it is only the member, or he can purchase by the member can also purchase from the non-member also. So that was the question before in the Assam Cooperative Bank. And in the Assam Cooperative case, the Supreme Court has taken a very strict interpretation and how this strict interpretation was there. And therefore, they have not considered the beneficial provision, and therefore it was subsequently reversed in the Kerala case here. We will see this part here. The expression engaged in the marketing of the agriculture produced by its member came from the decision, came up for the decision before the court. The court held that the object of this provision is that the agriculture produce that is produced by the members alone, I'm highlighted part, it says that that's a member alone would be entitled to such deduction. It further held that the object cannot extend to the traders dealing with the agriculture produce, so that if the agriculture produce is brought from the agriculturist by members, but not produced by the such member itself, such produce would not qualify for the deduction. So it was the first case, and that first case in the 1994, and that in the Assam Cooperative Bank. And here the Supreme Court has given a very strict interpretation of the then section 81, and the term that was discussed thereon, that engaged in the marketing of the agriculture produce of its member, and the same term is coming into the section ATP 2A3 right now. However, we will see how this judgment was reversed by the Supreme Court. This judgment was reversed in the Kerala State Cooperative Marketing Federation case here. The Kerala State Cooperative Marketing Federation, ORS, this one, that was 1998, overruled the aforesaid judgment. The question was the question which arose before the court in this case was the identical question that arose in the Assam Cooperative case, and the avatar of the provision, and having engaged in the ATP 2A3 of this act. And you see, let's see how in the Kerala case, Supreme Court has turned the earlier case of the Assam, and how they have interpreted the term. I'm trying to read, because it is the judgment, so I'm trying to read quote here. We may notice that the provision as introduced with a view to encouraging and promoting growth of the cooperative sector in the economic life of the country, and in pursuance of the declared policy of the government. Very much important. Which act has come for the purpose of beneficial provision? Which act has come for the declared policy of the government here? The correct way of reading different heads of exemption enumerated in this section would be to treat such each as a separate and distinct head of exemption. Very important line is that how to read an exemption here. It says that the correct way of reading a different heads of exemption, if we have a different head of exemption, we have to read it independently and not combinedly. The correct way of reading the different heads of income enumerated in the section would be to read that each as a separate and distinct head of exemption. Whenever a question arises as to whether any particular category of income of a cooperative society is exempt from tax, which has to be seen is whether the income fell within any of the several heads of exemption. If it is fell within any one of if it is failed any one head of exemption, it would be free from tax, notwithstanding the tax, notwithstanding that the condition of another head of exemption are not satisfied, and such income is not free from tax under the head of the exemption. It is a very good judgment here, which says that how to read an exemption and particularly how to read a beneficial provision. It says that each of the head of the exemption has to read separately, even though while reading the same, if one exemption, one income is exempt under the one category, that should be given the exemption, even though we find subsequently that there is a contradictory view that that exemption is not there, we will not go to read it combinedly. The expression, therefore, the expression marketing is an expression wide import. Now there, the Supreme Court is laying down the term stress on the marketing. Marketing is coming under the ATP A3. Its expression, it involves that exchange functions such as buying and selling, physical functions such as storage, transportation, processing, and other commercial activities such as standardization, financing, marketing, and intelligence, such activity can be carried out by the apex society rather than the primary society. I'm reading the judgment itself here. So as long as the agriculture produce handled by the SSC belong to its member, it is entitled to exemption in respect of the profit derived from the marketing of the same. Whether the members came by the produce because of their own agriculture activity or whether they acquired it by purchasing it from the other cultivators was of no consequences for the purpose of determining whether the SSC was entitled to the exemption. So we can see the line of departure, how the Supreme Court is analyzing the exemption provision, and while analyzing the exemption provision, we are seeing that Supreme Court is saying that no, hold on. It is not only the members grown by the members, but even if they purchase from the other members also, that will also qualify here because it is a beneficial provision. So in the beneficial provision, there is elasticity is there, it is expansive definition is there, and therefore they are trying to interpret that part here. The only condition required for qualifying, the SSC income for exemption was that the SSC business must be of the marketing, marketing must be of the agriculture produced, and the agriculture produced must have belonged to the member of the SSC society before they come up for the marketing, whether it's on own account or on account of the member themselves. Thus, there is no scope of, there is very much important life in there. There is no scope of limit the exemption. The exemption cannot be limited here. The cooperative society are engaged in the marketing of agriculture produced both by the members as well as the non-members. In the latter case, there is no difference between the cooperative society or the other business organization, and it will not be entitled to the exemption. The exemption is intended to cover all cases where the cooperative society is engaged in the marketing agriculture produce of its member. Section 80P2A3 does not in effect limit the scope of exemption to agriculture produce raised by the member alone, but includes the agriculture produce raised by the others also, but belonging to the cooperative society. This contrast in the said provision of this reference is to the marketing of the agriculture produce of the member society, and that purchased from the non-members. So here we can see that how the Supreme Court is interpreting the Section 80P, saying that since it is a beneficial provision, there can be elasticity can be there, and is trying to read that what is important here under the 80P3, the marketing of the agriculture produce. If the marketing of the agriculture produce is being done, whether it's grown by the members or non-member also, that is there. It does not say, so it does not debar you that non-members cannot be complement here. So this is the point that was coming here. On reading of the provision of 80P of the Act would indicate the manner in which the exemption under the said provision are sought to be extended. Now you see the expansive definition of the exemption is being expanded here. Whether the legislature wanted to restrict the exemption to a primary cooperative society, it was to made it clear, as is evident from the clause F referred to above with reference to the milk cooperative society and the cooperative society engaged in the supplying milk and is entitled to the exemption, which while denying the same to the federal milk cooperative society. So it is the same thing here. And after this, the Supreme Court is coming here in the last line. Thus, when the provision of 80P of the Act admits a wider exemption, there is no reason to cut down the scope of the provision indicated in the Assam Apex Court Society case. And based on this case, the Assam Cooperative Society case was turned around by the Supreme Court. The Assam case was reversed. The attention of this court does not seem to, the attention of the, what is the observation of the Supreme Court in the Kerala case? In the Kerala case, Supreme Court says that attention of the court was not seems to have been drawn by the aforesaid decision while deciding the Assam Society case. With respect, we therefore hold that the view taken therein requires reconsideration, as stated earlier by us. In this result, the order of the in the result, the order of the Kerala High Court following the decision of the court of Assam Cooperative Society Court is reversed. We hold that the society engaged in the marketing of agriculture produce of its member would not mean only such society which deal with the produce raised by the members who are individual, or society which are member thereof, which may not have purchased such goods from the agriculture. Thus, we allow the civil appeal that was there here. So with all these things here, the Kerala, the Assam case was reversed. The Kerala court, the Kerala case will prevail, and in the Kerala case, we have seen that the Supreme Court has already laid down the law that the 80P is a beneficial provision. When the 80P is a beneficial provision, we have to abide by that part here. Now, I'm coming to the citizen case here, very much because it is the citizen case on which the larger bench, full bench of the Kerala High Court has relied. And let's see what is the full bench says here. We mentioned that at the outset that there cannot be any dispute to the proposition of 80P of the Act as its benevolent provision, which is enacted by Parliament in order to increase and promote the growth of the cooperative sector in
सर वॉइस नहीं आ रही है.
हेलो,
आई थिंक कि शायद कनेक्टिविटी इशू है कुछ प्रकाश सर के.
हाँ मुझे भी
हाँ, लॉग आउट हो गए हैं अभी वो, मेरे ख्याल से फिर लॉग इन दोबारा हो जाएंगे अभी.
हाँ दोबारा कर रहा था, लॉग आउट हो गया.
हाँ, मुझे ये बनाओ ना, होस्ट बनाओ ना।
कर दिया।
Am I audible?
ऑडिबल है बट वीडियो नहीं आ रही है।
हाँ, पता नहीं क्या हुई। सचिन जी, मैडम, आप मुझे ये बनाएंगे, होस्ट बनाएंगे तभी आ सकता है शायद।
सचिन सर आप होस्ट बना दीजिए, आप अभी होस्ट हैं क्योंकि।
यस, नाउ इट इज कमिंग।
हाँ
आप मुझे ये बना देंगे, अटेंडी बना देंगे, आप होस्ट बना देंगे।
सचिन
कर दिया
सर
सर,
कैन।
कर दिया, कर दिया सर, अभी हो जाएगा।
या अब देख सकते हैं सर हम।
यस यस, करेक्ट।
It is coming here.
यस सर।
यस सर, यस सर।
So what we were deliberating, very important part here, the how to read the judgment here. Here the beneficial provision has to be read liberally, reasonably, and in favor of the SSE. That was the Bajaj Tempo case that was there. It was also tried that such a provision has to be considered as to effectuate the object of the legislature and not to defeat it. So it says that you have to give a purposive interpretation here, and that was from the Mahindra and Mahindra case. Therefore, it hardly needs to be emphasized that all those cooperative society which fall within the purview of 80P of the Act are entitled to deduction in respect of any income referred to in Section 2 thereof. Clause A of Section 2 gives exemptions to the whole of the profit gains of this work. So therefore, it says that if you read liberally, yes, the benefit can be given here. The 80P was further similarly was interpreted by the Punjab Haryana High Court in the case of the Punjab State Cooperative Bank. I'm not going to do this was, and this is the gist of the what is the gist of the citizen case here, and this is the gist here. What the gist is, the Section 80P of the IT Act is a benevolent provision which has enacted by the Parliament in order to encourage and promote the growth of the corporate society generally in the economic life of the country, and must therefore be read liberally in favor of the SSE. That once the SSE is entitled to avail the deduction, the entire amount of profit and gains of business that are attributable to one of the activities mentioned in 2 of the ATP must be given by way of deduction. It says that it is a general rule that is say the one, it is a benevolent provision. Once the SSE is entitled for deduction, is available for deduction. It's very much important. We have to find out the difference between the Dilip Kumar case here, that was a larger bench Supreme Court judgment, whether this is any contradict from the larger bench Supreme Court judgment. Although it has not been discussed here, we are not going into this part because that will lead the debate to a higher forum here. In fact, and it will take much more time. That once the SSE is entitled to avail the deduction, so what we have to see at the entitlement, we have to see the entire amount of the profit and gains business that are attributable to one or more activities mentioned in the Section 2 of the ATP must be given by way of deduction. So what we have to see, say, if at the threshold you are allowed, so after that there should be liberal interpretation should be given. Thus, the court in the Kerala Cooperative Society Marketing Limited has construed the Section 80P widely and liberally, and holding that if the society were to avail the several heads of deduction and which is fell within any one head of the deduction, it would be free from tax, notwithstanding that the other condition or other head of deduction are not satisfied. Very much important argument is interpretation is coming on from the Supreme Court. It says that his or her region, his region for the legislature wanted to restrict the deduction of a particular type of corporate society, such as the evident from the ATP to be qua the milk or the cooperative society. The legislature expressly shows. The section of ATP 4 is the nature of the proviso. In the Kerala High Court, they already say that it is a nature of, sorry, in the citizen, it says that the ATP 4 is the nature of proviso to the main proviso contained in section ATP 1 and 2. This proviso especially excludes only the cooperative banks, which are cooperative society, which must possess the license from the RBI to do the business. Given the fact of the SSE, the case was in the case that since it was no license, the SSE would not fall under the ATP 4. So the SSE has come to the court has come to that it will not form under the ATP4. And now the court is coming. What is how to read the judgment? Because the Kerala High Court full bench has misread the judgment of the citizen case here. Then the court is telling that we have to read the ratio decidendi of the case, not the outcome of the case. What is the principle of law laid down by in the case? And these are the few lines. What is the ratio decidendi? Because it is the ratio decidendi which is important. What is the principle of law that is coming? And it is, and this precedent is and this ratio decidendi is called a precedent here as per the Article 141 of the Constitution here. I'm not going into the detail of but I will go further into detail. CDN we have discussed about and after that we will come into the analysis. Now come to the section analysis of the section ATP. So one set that we have seen that it says that beneficial provision we have to give a wide interpretation, and now we have to now we will go to see what is the literal interpretation of the ATP. Literal interpretation of that. If we see that ATP, what is the ATP? ATP, the direction is that the head note is that income in respect of the cooperative society. So ATP talks about deduction in respect of the income of the cooperative society. The moment it talks about the cooperative society, how to read this head note here that came before the Supreme Court in the KP Varghese case versus income tax officer, and the Supreme Court has laid down how to read this part. The interpretation of the section 2 is strongly supported by the marginal note, how the marginal note has to be read, whether the marginal note has to be read, has to give what is the implication of the marginal note, how the section has to be read. I'm not going to the detail of that part. I'm just coming to the provision here. The deduction in respect of the cooperative society, KP Varghese, we have just discussed. Secondly, the eligibility of deduction. Yes, here the discussion starts. Secondly, for the purpose of eligibility of deduction, the SSC must be a cooperative society. It says that the exemption is to the cooperative society. A cooperative society is defined under section 219 of the Income Tax Act as being the cooperative society registered under the Act, registered under the Cooperative Society Act 1912, under any law for the time being in force in any state of the registration of the cooperative society. This therefore refers only to the factum that the cooperative society being registered under the 1912 Act. So once you are registered under the 1912 Act, the AO should not go further. There is no power of the AO to go further. It says that you are registered under the 1912 Act, you are covered, or under the state law. For the purpose of eligibility, it is unnecessary to probe any further as to whether the cooperative society is classified X or Y. So it says that once you are registered, you are covered. Thirdly, the gross total income must include the income that is referred. So these are the things that we should know how to, it is the gross total income. Fourth, the fourth clause is that in the clause of 2A1, it speaks of the cooperative society being engaged in. What it talks about that what the term is there, engaged in. Engaged in, the term engaged in came up for the discussion in the case of the Pony Sugars and Chemical, that was N 9 SSC 337, and it says that the term engaged in has to come from the fact of the case. The tribunal has to be make sure that the SSC is engaged in, and here there is no doubt the SSC is engaged in. There is no dispute on that SSC that is not engaged in. Fifth point, that as the SSC, as it has been held in the Uday Sahakari Upbhokta Thok Bhandar Limited case, the burden is on the SSC to show by adducing fact that it is entitled to claim the deduction under the ATP. We know that it is already settled that it is not under Udaipur Sahakari. There are a lot of cases where if you have to claim the exemption, the burden is on the SSC. Therefore, the assessing officer under the IT Act cannot be said to going behind the registration certificate. When the SSC is producing the certificate, the AO should not go behind the certificate. It says that. So once the task is fulfilled by the SSC by placing reliance on such fact as would show that it is engaged in providing the credit facility to the member, that the assessing officer must then scrutinize the same and arrive to the conclusion as whether it is in fact so or not. So if the SSC has declared that it is providing the benefit to a credit facility to a member, then it should be accepted here. And in this fact, the AO has already accepted that it is providing the credit facility to a member. Only point is that the number of members are nominal or negligible, and there are non-member also. But as far as the member is there is no denial that SSC has not provided the credit facility to its member. Sixth part is that it is important to note that it, as has been held in Kerala State Cooperative Society, the expression providing credit facility to its member does not necessarily mean agriculture credit alone. As I have mentioned, that does not say that it is only the agriculture alone. Section 80p2 80p being a beneficial provision must be construed with respect to the object of furtherance of the cooperative society movement generally, and section 80p2ai must be contrasted with the 80p2a3 to 5, which expressly talks about the agriculture. So 80p1 does not talks about the agriculture. Once it is clear that the cooperative society in question is providing the credit facility to this member, the fact that it is providing credit facility to its non-member does not disentitle the society in question from availing the deduction. This deduction, the deduction between the eligibility for the deduction and the activity of the amount of profit and gains to such activity is real one, that then it will, the computation part will come. Seventh part is that once it makes clear that ATP is concerned with the cooperative movement generally, and therefore the moment the cooperative society is registered under the 1912 Act, a state act is engaged in the society may be termed as a restitutory activity not covered by the subclause A to B, either independently or in relation to their part, then profit and gains should be attributable to their part, should be allowed here. After that, they have come to the budget memorandum, and in the budget memorandum and in the circular, it has already been clarified. I'm just reading the budget memorandum. What was the budget? In the budget, what was the amendment? The para number 166 of the Finance Act. Cooperative banks, like any other banks, are lending institutions and should pay tax on the profit. Primary Agriculture Credit Society (PACS) and the Primary Cooperative Agriculture and Rural Development Bank stand on a different special footing and will continue to be exempt from the tax under 80p of the Income Tax Act. However, I propose to exclude all other cooperative banks. So the only exclusion was on the cooperative bank. What was the circular? Circular says that the cooperative banks are the functioning at par with the commercial bank, which do not enjoy any tax benefit. Therefore, 80p has been amended by a new section 4 has been inserted to provide that the provision of the said section shall not apply in relation to the cooperative bank other than Primary Agriculture Society or the Agriculture and Rural Development Bank. The expression cooperative bank, primary agriculture cooperative bank, and primary agriculture has been defined there. That is not what. So through the circular, through the instruction, government is clarifying that it is only the cooperative bank which has been excluded under the ATP4, not the cooperative society. Again, there was a clarification. I'm just reading the clarification. In this regard, I have been directed to state that the subsection 4 of the ATP provides that the deduction under the section shall not be allowable to any cooperative bank other than Primary Agriculture Credit Society or a Primary Agriculture Rural Development Bank. For the purpose of this subsection, the cooperative bank shall have to meaning assigned to this. So and to the Banking Regulation Act. So they have till the cooperative bank will be assigned to this meaning here. What is the difference between cooperative society and a cooperative bank? So there is a regulation which talks about the section 22 of we have to, for this purpose, the section 22b we have to go and we have to analyze the Banking Regulation Act, which says that a cooperative society cannot enter into the cooperative bank business, and for the purpose of cooperative bank, it is the RBI license is important here, and in this case, the RBI license was not there. Application for the license. The SSC has applied for the license, whereas the license was denied by the RBI, or what the RBI has says. Please refer to your letter of application dated April 10, 2013, requesting to the banking license. On the scrutiny of the application, we observe that you are registered as a Primary Agriculture Credit Society, PACS. In this connection, we are advised the RCS, this is my registrar of cooperative society, but later dated this one here, that in terms of section 3 of the Banking Regulation Act, PACS are not entitled for the obtaining the banking license. It says that you are not entitled, so therefore you cannot be covered here. Now it is the summary of the judgment. What is the summary here? To come up with the ratio descendi, how to read the ratio descendi, which was the major mistake by the full bench of the it was a major problem of the full bench of the Kerala High Court. So the Supreme Court says how to read the ratio descendi. To sum up the ratio descendi, of a city and cooperative bank, cooperative society limited, must be given effect to Section 80P of the IT Act, being a benevolent provision to encourage and promote the credit of the cooperative sector in general, must be read liberally and reasonably, and if there is an ambiguity, in favor of the SSC. It is a departure from the Dilip Gupta case here. I will go into that part here, because a direction that is given without any reference to any restriction or limitation cannot be restricted or limited by the implication, as is sought to be done by the revenue in the present case, and in adding the word agriculture into Section 80P2 when it is not there. So the word ATP in the ATP2(1)(a), there is no word of agriculture. Further, ATP4 is to be read as a proviso, which proviso now especially excludes the cooperative banks, which are the cooperative society engaged in the banking business. So ATP4 has to be read as a proviso. Just on these three touchstones, it is clear that the impugned full bench judgment is wholly incorrect, and its reading in its reading to the city and cooperative society limited. Clearly, therefore, once Section 80P4 is out of the harm way, all the SSC in the present case are entitled to the benefit of the deduction contained in the ATP2A1, notwithstanding that they may also be giving loans to the member which are not related to the agriculture. So the Supreme Court has clarified that even if you are giving to the loans to the members which are not for the agriculture purpose, you are entitled here. Also in case it is found that there is an instance of the loan being given to the non-member, profit attributable of such loans obviously cannot be deduced here. With this, I am coming to the conclusion. I have concluded one judgment. I have concluded one judgment thoroughly, and I'm ready to take any question on this point of view. Sachin ji, Asa ma'am.
Yeah. जी सर, थैंक यू वेरी मच सर। बहुत ही डिटेल से आपने किया है, पूरा डिटेल से हमें एक्सप्लेन किया जजमेंट को।
मेरा ये मानना है,
एक क्वेरी हमारे पास है।
मेरा ये मानना है कि
एक क्वेरी, हाँ,
even if we try to read one judgment here, we should read the one judgment thoroughly here, because when we read one judgment, we should not simply sit and read the conclusion कि ये क्या conclusion हुआ, कोर्ट ने क्या कहा। और मैंने देखा है बहुत सारे लोग जो है सिर्फ conclusion पढ़ते हैं।
We generally do कि conclusion पढ़ के और
we should not read the summary. Generally मैं देखता हूँ कि लोग summary पढ़ते हैं। Please do not read the summary. Please read line by line. And यहाँ से आपको मिलता है कि कैसे कोर्ट का मार्चिंग कैसे चला, कोर्ट ने क्या क्या व्यू लिया, और कोर्ट ने किसको ओवररूल किया, किसको ओवररूल नहीं किया, and how the fact was presented. With this understanding, it gives a complete picture here. And इससे आपको मालूम चलता है yes how to argue the cases here. मेरा main purpose ये है यहाँ पाने का, to tell my fellow members here how to argue the case before the AO, how to argue the case before the any appellate forum here. अगर मैं कंक्लूजन बताऊंगा तो कंक्लूजन तो सभी को मालूम है मैम।
नहीं, ठीक, करेक्ट बात है सर। सर एक क्वेरी हमारे पास आई है अविनाश पराशर जी की। वो बीच में उन्होंने पूछा था कि डज प्रिंसिपल ऑफ म्यूचुअलिटी आल्सो अप्लाई?
Here in this case the principle of mutuality was not discussed, ma'am.
Okay.
Yes, apply करता है. There is in fact there is a judgment of in this. In fact, one of the para is on the principle of mutuality here, but that has not been deliberated much, and I'm not going into the principle of mutuality here, because look, what was the principle of mutuality? If we go on the principle of mutuality, in fact, this came from the Young India judgment, 1970 judgment that was there. And after the Young India judgment, we have seen that was deliberated more in the Calcutta Club case, which was before the Supreme Court, and it was Nariman case itself here, Nariman and Surikant Sikla. And they have discussed what was the impact of the mutuality and the Young India case. And it was the article, how the Article 366, 29A, D and E came before the Constitution through the 42nd Amendment. What was the impact of that part, and how it has affected the sale tax, how it has affected the service tax, and how it has affected the GST. And we can see that there was a recent amendment in this budget 2020 itself, where the GST amendment in the GST. Now the mutual society will be covered here because the language of that has been totally changed. So I will say that mutuality concept, as far as the GST is concerned, right now it is a dead.
तो आई होप आशीष जी की क्वेरी रिजॉल्व हो गई होगी. अगर नहीं हुई है सर तो यू कैन ऑलवेज रेज योर हैंड, तो आपको अलाउ कर देंगे उसके, ताकि आप डायरेक्टली पूछ सकें अपना क्वेरी. एंड सचिन सर, एक हैंड रेज है अशोक जी का, तो इफ यू कैन अलाउ हिम टू टॉक.
यस अशोक सर, अलाउ कर दिया इसमें.
Ashok ji, you can raise your query.
Yeah, can I speak now? I'm already.
Yeah, please, sir.
Yeah.
Yeah, you are audible.
At the outset, as you rightly said, it was an excellent presentation. It was 67 pages judgment, analyzed threadbare in 2 hours. We will not be able to read and understand this judgment in 2 hours, but then Prakash ji has described it very well. Prakash ji was saying, one question he has raised in between. He was said even before amendment whether cooperative society was eligible or not. Prakash ji, according to me, under subsect clause A, cooperative societies were eligible. Is there any doubt on that?
Yes, sir. Actually, I was just first of all, I would like to appreciate Ashok Sharma sir. He is my mentor, and I will tell you, and he's joining from Bombay. He's joining from Bombay. So let's appreciate and
thank you so much, Ashok sir.
My pleasure. And see, I'm also like Prakash ji. I'm also always looking to for studies only, and see. Otherwise, as I said, you will not read in such a great detail. For 2 hours speaking, I don't know how many hours he must have spent. Maybe 8 hours, 10 hours, I don't know, and you get the benefit in 2 hours. And that also crystal clear. It was really, I'm not exaggerating anything. It was very good analysis. And even if you are not read, anybody has not read the judgment, you will understand the whole thing. Yeah. So, sir, I was saying, you are saying something, sir.
Sir, I was saying that if you read the statute here, if we come to the ATP, sir, okay, sir.
Yeah.
ATP was, if we come to the sum referred to in subsection 1, shall be the following, namely, in the case of cooperative society engaged in carrying on the business of banking or providing credit facility to its member. So it was there. So this provision was since inception, sir. If we come to the ATP4, ATP4 was, if we come to the ATP4, this section, this provision was there, and this provision was just hold on, sir, 94, yes, 94, inserted by the Finance Act 2006 with effect from the 1st April 2007. Earlier, this subsection 4 was omitted by the Finance Act 1969 with effect from 1470. So up to 69, this section was there, already there. On 70, this section was deleted here. This section was omitted here. And this section was again came to the issue after they again came to the statute through the subsection 4. Now the point is that here there was also mentioned that it was a cooperative bank. And the main section was always available to the cooperative society. The point I'm trying to say, there was always a difference between the cooperative society and the cooperative bank. The cooperative bank is covered under the Banking Regulation Act, which says that if you have a license to operate as a bank, as per the RBI regulation, as per the banking regulation, the cooperative society was never allowed to enter into the cooperative bank here, into the cooperative bank. There's a difference between the cooperative society and cooperative bank. And in fact, I have covered this case in my one of the slide. If I allow me to go few minutes, I can go that part here. Yes. I'm reading this part. As per the Banking Regulation Act 1949, Section 3 read with Section 56 is that the primary cooperative bank cannot be primary agricultural credit society. It was there since 1949. As such, the cooperative bank must be engaged in the business of banking as defined in the 5B of the Banking Regulation Act, which means that by accepting for the purpose of lending of investment or deposit of money from the public. Now come to the second para, sir. Section 22 1B of the Banking Regulation Act as applicable to the cooperative society. No cooperative society, sir, very much important. No cooperative society shall carry on the banking business in India unless it is a cooperative bank and holds a license issued in that behalf by the RBI. So even if the cooperative society was there, you cannot carry on the business of the cooperative bank. And therefore, even if the ATP4 was not there, I will say that ATP is operate totally on a different angle. Even the ATP4 was not there. It was allowed for the deduction because the cooperative society cannot go into the domain of the cooperative bank.
I appreciate. Yeah. And secondly, you said about Dilip Kumar said, Dilip Kumar.
Yes, sir.
Sir, we are always saying whether Bajaj case is overruled or whether it can be read. We have to read after Dilip Kumar in a different way. In one of the, I will try to get those slides from Mr. Chaitanya for half an
Yes.
hour. I don't know whether that in one of the institute's program he has analyzed Dilip Kumar case. And he said that was on the facts of the case as per the provisions of the indirect tax provision.
Yes.
And it was a notification. And Dilip Kumar doesn't overrule or we have to read in a different way than other than Bajaj Tempo, etc.
Yes, yes. I totally agree with you, sir.
Yeah.
In fact, when I was reading this judgment, I was trying to understand, is there any discussion on the Dilip Kumar cases here?
Yeah.
Because the Dilip Kumar cases was never brought by the revenue here.
Okay.
And in fact, when I have read this judgment, I thought that the revenue will raise this of the Dilip Kumar judgment here. But the revenue didn't brought this revenue, the Dilip Kumar judgment here. Why? The Dilip Kumar judgment was on the indirect tax. First of all, then we have to understand the difference between direct tax and indirect tax.
Yeah.
In the Dilip Kumar judgment, there was a notification that was under the challenge.
Yeah.
And the notification was through the exemption notification was there.
Yeah.
Here the exemption is through the statute itself.
Yeah.
Here the judgment was here the exemption deduction is from the statute itself. So when we are trying to read all this part here, so we have to complete silos here. And I have not compared that part here. But yes, I feel that the Dilip Kumar judgment may not applicable into this part here.
See, Dilip, there was a doubt in my mind since last 3-4 years since when the Dilip Kumar case had come, but then nobody has analyzed that. But as I said, Mr. Chaitanya last month only in one of the seminar, he analyzed very beautifully. I will try to get those slides and we'll discuss that afterwards. But as you are saying, the similar way only he has analyzed that. Yeah. So once again, enjoyed thoroughly. Any other participant, if he has any question? Yeah.
सर आपको बहुत बहुत नमस्कार सर.
नहीं सर, नमस्कार. मेरे हमारे काम को हमेशा याद करिए. I am always ready for such things, sir.
सर मैं आपको बता दूं, यहाँ पर जो भी लोग हैं, शर्मा साहब is the head of the study circle on the direct tax of the Chamber of Tax Consultant at Bombay. And and it is my blessing that I am deliberating in his presence here. His knowledge is tremendous here, and his deliberation is tremendous here. We should be feel blessed that he is here.
We also take inspiration from you, sir. How much? Let me tell you one more thing, sir. Today only in our committee that for residential course, that virtual RRC, we were discussing about the group leaders. And when you also have applied for group leading in that virtual RRC, and that members attending were saying in company law you discussed very well. That you were the group leader in company law course also. So it is a joint deliberation. It's a common interest, sir. What is your interest is my interest. And academically, I say always we get many things by attending this such seminars, webinars.
Yes,
sir. Thank you so much, sir.
Thank you, sir. Thank you.
Yes. Yeah.
Thank you, sir.
Sharma sir, we would request you and love to hear you in our next webinar. Whenever
Yeah.
you can
See,
give us time. We will
yeah,
be
no, definitely I'll be
highly obliged.
participating. My only problem is I means I'm not that computer savvy. So but always I'll be able to discuss and participate. Of course, I will prepare also for something, and definitely you'll do it. Sinaji has got the wealth of knowledge, so we can first take it from him.
Sir.
Yeah, I will also definitely participate. It's my pleasure and my passion also to learn these things.
So we have also started publishing our monthly newsletter also on direct access.
Okay.
So you can
Okay.
always give your
Sure.
blessings and your article
No.
in our newsletter.
Oh, sure,
That will
madam.
be for
Sure.
our readers.
No, sure,
worship.
madam. Sure.
Thank you so much, sir.
Thank you.
Thank you, Sharma sir. Thank you.
Thank you, sir.
Thank you, Prakash sir, for I would like to take the opportunity for formal vote of thanks. एंड सर थैंक यू सो मच, बहुत ही डिटेल से आपने हमें, इट वाज नॉट ओनली ए केस लॉ, इट वाज लाइक कि आपको कैसे प्रोसीड करना है, कैसे पढ़ना है किसी भी चीज़ को, कि एक असेसिंग ऑफिसर के लेवल से उठता हुआ केस सुप्रीम कोर्ट तक पहुंचता है, क्या क्या चीज़ें उसमें होती हैं, क्या हमें देखना है, किसके पास कैसे रीड करना है. तो डेफिनेटली जिन्होंने हमें आज लाइव सुना एंड आगे जो भी यूट्यूब पर इसको देखेंगे, आई एम श्योर कि बहुत ही अच्छी एक लर्निंग होगी उन लोगों की. एंड थैंक यू सो मच सर, एंड थैंक्स ऑल फॉर ज्वाइनिंग अस.
मैडम प्रकाश जी तो मुझे हमेशा भेजते ही है लिंक वगैरह, आप भी मुझे इंफॉर्मेशन भेजते रहिए.
Sure, sir.
बिल्कुल सर.
Yes sir, thank you.
Okay, thank you so much.
Thank you very much, sir.
Thank you for giving me the opportunity. Thank you, Jitendra Sharma sir.
धन्यवाद सर, बहुत बहुत धन्यवाद सर. सर ने एक चीज बताई ना कि खाली इनकम टैक्स से नहीं, हमें काफी एंगल से जाके अपने केस को प्रेजेंट करना चाहिए, तभी हम उस काम में कर पाए. खाली हम इनकम टैक्स को पढ़ते हैं उसके बेस पे नहीं हो पाता. बहुत चीजें उससे रेलिवेंट होती हैं, जो रेलिवेंट सेक्शंस होते हैं, जो रेलिवेंट की वो है लॉ है, उसके बेस के अलावा ही बहुत काम करना पड़ता है.
And that's true कि many a times हम conclusion read करके और अपना केस लॉ कोट करते हैं और अपील फाइल कर देते हैं. That should not be done.
In fact, in our office, we always read the Constitution. First of all, we always read a Constitution before going to any statute, whether it is an income tax statute, whether it is a corporate law, or any customs or any FEMA matters. We will first read the power कहाँ से drive होता है, how to read the Constitution here.
And jurisprudence भी सर काफी काम आता है उसमें. हाँ, jurisprudence भी पढ़ना चाहिए थोड़ा सा.
हाँ, jurisprudence भी पढ़ना चाहिए. If you read the Constitution, jurisprudence, then we will able to appreciate how the law कहाँ से flow हो रहा है. And if the law का flow हम लोग को समझ में आएगा, then हमें समझ में आएगा कि कैसे argument करना चाहिए. Otherwise, simpliciter एक्ट को पढ़ करके कभी भी आर्गुमेंट के लिए या एज ए लीगल काउंसिल, जो हम लोग लीगल काउंसिल है, हमें उस तरह से कभी नहीं हम लोग कर सकते हैं. हमें पूरी तरह से तैयारी करनी पड़ती है. एंड नॉट ओनली वन एक्ट, we never prepare ourselves for the income tax matter by reading only the income tax act. We try to read only the many other act. Sometimes we try to read the labor code also. Sometimes we read the other law also and try to find out कि other law का interplay कैसा चल रहा है and which law will supersede here. So उस तरह से हमें करना पड़ता है.
मैडम आप हेड नोट्स की बात कर रहे थे. हेलो.
Yes, sir.
If I take just 1 or 2 minutes.
Yes, sir.
One Mr. Soli Dastur, आपने नाम सुना होगा, topmost council in Bombay.
Yes.
Soli Dastur, Sohrab Dastur. Once he was arguing the matter in the tribunal. I was there in that court. One DR in the earlier day, he cited some 40-50 cases relying on his proposition. Mr. Soli Dastur, when he was answering or meeting all the judgment, he said, Your Honors, I was reading up to 3 o'clock. Out of these 40-45 cases, only 2 or 3 are relevant to our issue. And DR has also, and DR has cited, just we take they see the head note and cite it. So sometimes it can fire back also, no?
Yes.
Because this head notes are something else, and inside the judgment there is something else. So
Agreed.
what I want to say, you are rightly saying we have to read the whole judgment. And Soli Dastur, he is 90 now, around 90 years now, still topmost in Bombay, and arguing means go so minutely. Reading up to 3 o'clock at this age is not a joke.
Yes.
Yeah, that's all. Thank you.
Thank you, everyone. Sachin sir, I think now we can close.
Yes, now we can close. Thank you so much. Thank you, sir. Thank you, Prakash ji, for nice deliberation. Thank you, Jitendra ji, for organizing the excellent webinar. And thank you, Asa ji, for moderating the session after a long travel. You accepted our proposal and you are here for moderating the session.
That is for my benefit, sir.
Thank you to all audience. Thank you so much.
Thank you. In fact, मैंने एक ही केस लॉ लिया अभी तक, दूसरे केस लॉ में पहुंच ही नहीं पाया मैं तो.
We'll plan for next Friday. We'll plan for next Friday, sir.
Okay. Thank you.
Right.
Thank you.
So much.
Thank you.